Yes, good evening to all the participants of the JCJ 2022 main examination. Yes, anyone can unmute and read what I posted on the screen. Quick.
Good evening to the aspirants of 2022. General exceptions under Indian IPC and culpable homicide amount to murder, Section 300 of IPC, Kolikonda Sharad Babu and Professor MS Hussain.
Whenever you speak, keep your gadgets very near to your mouth. So that voice is
Yes, sir.
SONOROUS, sonorous voice. The right pronunciation is sonorous voice. Okay. Like a lion and lioness. Okay, without wasting the time, let me go to the section 300. It clearly says of the IPC, except in the cases hereinafter accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. So exceptions are given over there in the 300. And secondly, if it is done with the intention of causing the such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of the nature to cause death, like in an example we have dealt in yesterday class, if a person is a diabetic patient and if he knows it and if you make a small incision to him, then the profuse bleeding cause for his death. He knows it, intentionally he did so, then that is a culpable homicide amount to fill the blanks. Participants, culpable homicide amount to, are you hearing me? Participants, why you are not giving the reply?
Sir, please repeat the question, sir.
Yesterday, that example which I have given it, if a person is a diabetic patient and the person who made the incision to him knows that he is a diabetic patient, at the time, profuse bleeding is caused to him and that culminated into, and that offense is called culpable homicide amount to I2.
Murder.
Not murder.
If he knows it, it is a murder. If he doesn't know it, it is a culpable homicide. Repeat. Repeat.
If he knows it, it is a murder.
If he knows it, it is amount to culpable homicide, amount to murder. If he doesn't know, he is the culpable homicide, not amount to murder. I said repeat it in that way. Not culpable homicide, murder. Okay, now let us see the fourthly. If the person committing the act knows that it is so imminently dangerous that it must, in all probability, cause death or such bodily injury is likely to cause death and commits such an act without any excuse for incurring the risk of the causing death or such injury as aforesaid illustration. Now let us see the illustration A, small a. A shoots Z with the intention of killing him. Z dies in consequences and A commits a murder. It is very clearly made it. A shoots Z with the intention of killing him and A knows to whom that he is going to shoot. Am I right?
Yes, sir.
Good, I appreciate. That gives a sense that you are with me. Otherwise, saying to the wall. Is it clear?
Yes, sir.
Very good. So Z dies in the consequences because A directly have the intention to shoot Z, and that to be in the shooting range, and he died consequently, and it is amount to murder clearly. Another B example which is shown illustration A, knowing that Z is laboring under such a disease that a blow is likely to cause his death, strikes him with the intention of causing bodily injury. Z dies in the consequence of the blow. It is a guilty of murder. Although the blow might not have been sufficient in the ordinary course of nature to cause the death of a person in a sound state of the health. But a blow, as would not in the ordinary course of nature kill a person in a sound state of health, here A, although he may intended to cause bodily injury, is not guilty of murder if he did not intend to cause death or such a bodily injury in the ordinary course of nature would cause death. So here question is A, knowing that Z is laboring under such a disease. That means he is having the intention, but he has given a blow. But if he knows that the striking of a blow is enough for his causally bodily injury, and consequently that he is going to die, then it is amount to murder. If not, it is a culpable homicide only. And Jet dies in the consequence of a blow. And A is guilty of murder clearly. Is it clear? In general, that blow will not be sufficient in the ordinary course to ordinary and sound man, sound body person. Did you follow my point?
Yes, sir.
The question is consequences, whether he knows it. In ordinary course, that blow is not sufficient to cause the death of a person. And if you use the leg, you say it is a. If you use the leg to strike anybody, what do you say?
Kick.
K-I-C-K, kick. Appreciate. Clenched fist,
Blow.
throwing on the face of somebody with the hand. Clenched fist means only hand. What do you call?
Blow or
Participant should have to say, not the host. I said several times. Yes, say anybody, then you can make the chance. It is a punch. P-U-N-C-H, punch or it is clearly given here, B-L-O-W. Say,
blow.
blow. And if it is a open hand on the cheek, participants,
Slap.
if you give a slap to an ordinary man, can he die?
No.
No, sir.
But if you slap a man who is having such a disease, if any fly perch on his body, he will die. Even a small touch is enough for his death. There is clearly a murder.
Okay.
Did you get my point?
Yes, sir.
If you, with the open hand, give a strike on the BUTTOCKS, there is a specific word I already told. Did you understand my question first? Sir, answer is no. Now, even any person can make it out.
Repeat it, sir.
Striking in the open hand on the BUTTOCK. Say Pasan.
Yes. Then sometimes it may cause death also.
A particular name is there. Like a kick, punch, blow, slap. Say Pasan.
Pass on, sir.
SPANK.
Spank.
Only Professor Hussain students could make it out. It's an open challenge. Okay, now let us come to the point. Next. C. A intentionally gives Z a sword cut or club wound. Wound. I know that you know the what is club. CLUB club. Say yes.
Yes, sir. It was used by mythological warriors like Bhima.
Why Bhima when a policeman is having a club like a cane? And if especially when you see in the English movies, when he make the lathi charge and they use the club, and I am showing the images here, is a round one having a, oh, not this club, is the club for lathi charge. Club for lathi charge images. Did you see the club now? It's like a cane, but it's a hard one. The people are using the clubs and cane. But a particular type is there, which is a round one having it. It is a strong, a stick is called club. So, if you use the club, yes, it is enough. There is a good blow is there for the wound sufficient to cause the death of a man in the ordinary course of nature. Jed dies. In consequences, here he is guilty of murder, although he may not have intended to cause Jed's death. Actually, he doesn't want to cause the Jed's death, but intentionally gives a sword cut. Why he wants to give the sword cut? Tell me. Sir, to test whether sword is sharp or not. Why he doesn't make the test on himself only? So, any club or a sword cut? Yes, please share your views. Please share your views. See, I already told you when I was delivering the lecture, if I could see any sound would be there. My tongue is tied, my hands are handcuffed, my legs are fettered. Shall I proceed? Say yes. Good. So Jed dies in consequence. He is guilty of murder, although he may not have intended to cause death. You don't make an experiment on somebody else to see whether your sword is sharp or not. Experiment on your own body. Is it clear?
Yes, sir.
Good. So D, without any excuse, fires a loaded cannon into a crowd of a person and kills one of them. And I'm sure that you know what is cannon. Say yes or no.
Gun.
Yes.
Can I be gun?
Cannon means
Wrong. Tupaki is different. Topu. Have you heard topu?
Yes.
I will show you cannon. Cannon image. If you go to the old fort, you can see the cannons are there. In Urdu language, we'll say, did you see the now, the image? On the wheels,
Firangi sir.
on the stone, and they will fill it in front, and they will burn at the back, and it will explode. That is called?
Firangi sir. Firangi.
Yes, you are right. In Urdu, we'll say top. Yeah, now let us see that in cannon.
cannon also means a principle.
Oh, that is the cannons, language cannons, maxims. Language canon is there. I don't know whether you are studied the interpretational statutes.
Same spelling, but principle
Yes.
is the meaning.
So the language canon, I already gave some of the example there. Redando singulus singulis. Redando singulus singulis. I don't know how many people would know it. Yes, anyone?
We don't know, sir.
In the interpretation of statute, it is there. Language canon. You can draw the sword and you can load the pistol. You cannot interchange it. You can draw the gun and load the sword. Is it clear?
Yes, sir.
That is called redendo singula singulis. The word goes with certain subject matter only. Gun will be loaded and sword would be?
Drawn.
Sword would be?
Drawn.
Drawn. D-R-A-W-N-E-D. So now let us see. Though that is a language canon. But here the canon means Firangi or Topu. What do you say just now? Okay, now let us go to the next point here. A is a guilty of a murder, although he may not have had a premeditated, means pre-designed, designed to kill any particular individual. When you use the AK-47, keeping the nozzle at the mob, and you want to know whether the people will die or not. Yes?
Right, sir.
The clear intention is there to kill.
Sir, accidentally it is made. Even you are not supposed to touch the AK-47 when you don't know how to operate it. Number one. And when you want to hold it, keep the nozzle in the air. Number two. So, of course, there are many things would be there. We cannot say, I don't have intention to eat, but I want to say whether it is firing or not. Such an experiment, one should not do it. Exception 1. When the culpable homicide is not murder. When culpable homicide is not murder, if the offender was deprived of the power of self-control by grave and sudden provocation, causes the death of the person and who gave the provocation, or cause the death of any other person by mistake or accident, the above exception is subject to the following provisions. Of course, in some cases, provocation is a good ground for getting the exception to see that it's merely a culpable homicide.
Only clear concept as far as culpable homicide is concerned, which is not amounting to murder.
Yes.
In this only the clear concept is laid down, because if there is sudden provocation, we don't know what we are doing.
Yes.
We don't know whether even we are killing a person.
Yes.
If there is a sudden provocation. So culpable homicide doesn't amount to murder. In this case, clearly it is a clear concept.
Yes. And there is a very famous case law is there. And I repeated several times.
AM Nanavati versus State of Maharashtra, sir.
Is it a Maharashtra? Is it a Bombay?
Maharashtra, sir. State of
Maharashtra.
Maharashtra.
And he is a naval officer to whom he killed not participants only, not the Kolikonda. To whom he killed naval officer. Say, Pasa, and I will give the answer. Or I will ask the Kolikonda, sir, Sharad Babu.
Killed the paramour of his wife.
Paramore. తెలుగులో ఏమంటారంటే మిండెడ్ అంటారు. Paramour. Is it clear? Say yes.
Yes, sir.
Good. So is it a sudden provocation in that case law? Answer. Answer is no. Because he killed next day, not on the red-handed spot. Okay, let us see now the first exception. For whether provocation is there or not, how, on what grounds we can say the provocation. That the provocation is not sought or voluntarily provoked by the offender as an excuse for killing and doing harm to any person. So the provocation should not be voluntary. Is it clear?
Yes, sir.
Number 2, that the provocation is not given by anything done in obedience to the law or by public servant in the lawful exercise of the powers of such a public servant. A public servant, you cannot stop him from his duties. And if you say that if you stop it, do it is, and you say this is a provocation, no, you are not supposed to do such a thing because you are supposed to do. And you cannot say it's a provocation. And that the provocation is not given by anything done in the lawful exercise of the right of a private defense. When the private defense, that is the provocation not given by anything. Explanation, whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact. Of course, it depends upon. Let us see the one of the illustration. Can anyone can unmute, especially the participant, and read this A illustration? Unmute and read. Participants.
A. Under the influence of passion, excited by a provocation given by Z, intentionally kills Y. Z's a child. This is a murder in as much as the provocation was not given by the child, and the death of the child was not caused by accident or misfortune in doing an act caused by the provocation.
See, very clearly made. A, under the influence of the passion, excited with the provocation given by Z, intentionally kills Y, Z's child. Y is killed and Y is a Z's child. And this is purely a murder because provocation is not made by the child. Is it clear?
Yes, sir.
And who created the provocation?
Z created a provocation.
And Z is the father of the child. And this is a purely a murder.
Had he killed Z,
Child,
and
if the
Z
child,
killed
no, had he killed Z, I mean, why?
it would have been culpable homicide.
It will be the amount to the culpable homicide. If you would have killed, why? Is it clear?
Yes, sir.
And this is a murder in as much as the provocation was not given by the child. The child was not provocated the A, but his father provocated. Can you keep the father in the prison if the father's son made a murder? Answer? Yes, sir. No.
No,
No,
In the
sir.
criminal law, there is no vicarious liability. In civil law, there is a vicarious liability, but in criminal law, there is no vicarious liability. And the death of the child was not caused
son
by
is not
accident.
held liable for father's murder.
Yes.
Father murdered someone.
But for the father deaths, son would be held liable.
Yes, if he kills his father, then he will be held liable.
The reason is
That is patricide.
he is going to inherit the father's property in the form of succession, and hence
He will be
father
deprived of
liability would be his liability.
Yes, sir.
తెలుగులో అంటారు కదండి అత్త సొమ్ము అల్లుడు దానం చేసిందని. Why?
because it is not his own.
Because it is not his own property, it's the property of the mother-in-law, and this fellow wants to take the advantage of it. Okay, now let us see the B. Y gives a grave and a sudden provocation to A. Okay. On this provocation, A on this provocation fires a pistol at Y. Good. Neither intending nor knowing himself to be likely to kill Z. Z has come, but who provoked it? Y provocated. Then who was the victim? Z is the victim. Who is near him, but out of sight? A kills Z. Here A has not committed a murder, but merely
Culpable homicide.
why?
Because
Why?
Not intentionally.
He doesn't have any intention to kill Z, number one. Number two, it is Y gives a grave provocation and he wants to kill actually Y, but Y escaped by the chance behind the behind the Y, the Z may be standing over there. So I told one terminology here. Can you tell me? Not host, participants.
Repeat it, sir.
See, A wants to kill B. And he put the aim at the B. But when he pressed the trigger, B bent down. And behind B, C was standing. And C was killed. But A wants to kill B because B provocated him. But consequently, to whom he killed? C. Where is C? Behind the B. How the B did it? He lowered his head or he squat. And the bullet hit C. And who is behind the B? And A did not notice it. That instance, it is a culpable homicide, not amounting to murder. But I used another terminology, legal terminology. Can anybody will tell me the terminology? Intention is transferred. So what do you say? Transferred intention. Even transfer intention, he will be held liable, though not murder. Is it clear?
It is culpable homicide,
It's a
not
culpable
amount to
homicide.
murder.
So now let us D appears a witness. A appears as a witness before Z, a magistrate. Z says that he does not believe a word of A's disposition. Whatever the A says, he could not rely on it, believe it, and that A has perjured himself, and A is moved to sudden passion by these words and kills Z. This is purely a murder. Why? A appears as a witness before Z. Who is Z? A magistrate. What Z says? He does not believe a word of A's disposition. He doesn't trust A. Who doesn't trust A witness? Say
Magistrate.
Magistrate Z. And that A has perjured himself and he is provocated. And he moved a sudden passion by these words uttered by the magistrate and kills magistrate. It is not a culpable homicide amount to murder, it is a purely a murder. Because magistrate having the privilege to see
Legal aware.
and he say, I believe that your witness are not a proper. I believe that you are a wrong witness, or you are a false, or you are a liar.
He can say anything.
Yes, because such a privilege would be there under the Judicial Protection Act. And it is clearly a murder. Is it clear? Okay,
Yes, sir.
now E. An attempt to pull Z's nose. And Z, in the exercise of the right of private defense, lays hold of A to prevent him from doing so. A is moved to sudden and violent passion in consequence and kills Z. This is a purely a murder. Because who actually pulls whose nose? Participants, not the Kolikonda.
A
Continue.
attempts to pull Z nose.
And Jed want to avoid it and he made his hand to be lowered down or he moved it to prevent himself from such a activity under the private defense. But A agitated and got the sudden provocation, violent passion, and consequently kills Z. And this is purely a murder. Either he kills with a club or a cane or a stick or a blunt knife or a revolver or a sword. Is it clear?
Yes, sir.
So it is not amount to provocation as given by thing done in the exercise of the right of private defense. So now let us see Z. If Z strikes B, B is by this provocation excite to violent rage. A bystander, intending to take advantage of B's rage and to cause him to kill Z, puts a knife into the B's hand for that purpose, and B kills Z with the knife. And here, B may have committed only a culpable homicide, but A is guilty of murder. Why?
Because he put that knife in B's
He
hand.
supplied the knife, take the advantage of it, and A is guilty of murder, and the person who killed is only culpable homicide. So, explanation 2, culpable homicide is not murder if the offender, in the exercise in good faith of the right of private defense of a person or property, exceeds the power given to him by law and causes the death of the person against whom he is exercising such a right of defense without premeditation. So, without premeditation is more important factor, and without any intention doing the more harm than it is necessary for the purpose of such a defense. If the two things are covered over there, then we can say it is a provocation and it is not murder. Suppose if anybody throw a stone on you, can you take out the revolver and shoot at him? Answer is participants. Participants, don't sleep.
Give one or the other answer, whatever answer he wants to give. You want to
I don't
give.
know why they are keeping quiet. Do you think that this class is for myself?
Mamta Kaur,
Sir. Sir,
Should
He
I
has
respond
thrown
now?
a stone on B. B has taken the AK-47 and shot at the A.
Okay.
Is it a provocation?
No, sir.
Then it is amount to murder or culpable homicide or amount to murder.
This is
Culpable
murder.
homicide.
It is a purely a murder. The reason is in the private defense, you should use the proportionate force.
Okay.
The other man used the, you know that in the children they used to make fear the crow by using the stone in one of the rubber band by using the V shape. What do you call it in English? Not the host, participants.
English I don't know, sir, but Hindi guler.
Catapult.
Catapult.
Okay.
Catapult. If a person use the catapult and harms you, you cannot take the AK-47 and shoot at him. You should also use the catapult and use two stones, one for the capital, another for the interest. Is it clear?
Yes, sir.
So illustration, Z attempts to horsewhip A, not in such a manner as to cause grievous hurt to A. A draws out a pistol and Z persists in the assault, and A, believing in good faith that he can by no other means prevent himself from being horsewhipped, shoots Z, and Z died. He has not committed a murder but only a culpable homicide. If you use the excess force and there is no other go, and when you kill a person or a thing, it is not amount to murder. it is only a culpable homicide. I don't know whether you read that case law or not. In the law of tort, a shepherd taking his sheep and pigs from one place to another place for the grazing. But one of the dog has bitten some pigs and also bitten some of the sheep. And he used his cane to separate it. But still it persisted. And again it is attacked the pigs as well as the sheep. The third time again it is pursued to bite or to either the pigs or the sheep. Then the shepherd has taken the revolver or a gun and shot at the dog, and the dog died. Whether it is amount to offense committed by a shepherd? I don't know
No,
how many
because he
people
has
will remember
tried
the
in
case.
vain so many times to separate it, but
We can
still
say it is a necessity.
damaged his property.
He damaged his property, and hence he could have the last resort to kill the
Dog.
dog. Is a feminine gender or masculine gender? Participants. Participants. Why I am asking, I would like to know whether you are there or went for the bathroom or eating the food. Speak. Did you understand the question?
Gauzia is trying to speak something.
But why she is not speaking?
Sir, I didn't understand. Please.
Dog is a feminine gender or muscular genders?
Yes, tell me.
You shoot your answer.
Feminine gender.
Then what is the masculine gender? A feminine gender will say bitch, B-I-T-C-H. Okay, now let us go to the section 3. Culpable homicide is not murder if the offender being a public servant or aiding a public servant acting for the advancement of the public justice exceeds the power given to him by law and cause death by doing an act which he in good faith believes to be lawful and necessary for the due discharge of his duty as such public servant and without ill will towards a person whose death is caused. It is not amount to murder because he wants to do the public duty he is doing. At that instance, he can use the force. If any person stops it, and if he uses such a force would be there, then consequently he died, then it is amount to a culpable homicide, but not the murder. In the lathi charge, legally it is given, well and good. If the people died,
Can extend it
no,
to
nothing.
one illustration also, sir.
Yeah,
A soldier fires on a mob by the order of his superior officer,
yes,
in conformity with the commands of the law.
yes,
He has committed no offense.
naturally. Because he obeyed the law of his boss, and hence there he cannot be made. So, in this manner, it is immaterial in such case which party offer the provocation or commit the first assault. So, exception 5 is, yeah, now the time is, yes, 8:43. Kolikanda, you can go for that one because exception 5 is there, which is a self-explanatory. Okay, now it is your turn, and you said general exceptions. Yes, it is there.
Okay, sir. General exceptions under law of crime are from section 76 to 106. Of course, we have already discussed section 106,
Yeah.
which is private defense.
We can directly go to where?
And we shall start from 76. That
Okay.
is 76 and 79.
Okay. Mistake of fact.
This is mistake of fact. And second one is Judicial Act sections 77 to 78.
Okay.
And the third one is accident
Okay.
section 80. Just I am referring the sections.
Okay. Okay. No matter. Now go to the 76
Now
and
fourth one
79.
is absence of criminal intention sections 81 to 86 and from 92 to 94. The act done by consent is the fifth one, that is sections 87 to 91. Sixth one is Trifling Act, that is section 95. And the last one, seventh one, is which we have discussed, that is private defense, sections 96 to 106. Now let us confine to other general exceptions.
Starting from?
76.
Go ahead.
Sections 76 and 79, mistake of fact. This mistake of fact is sometimes a good defense. Section 76 lays down that nothing is an offense which is done by a person who is or who by reason of a mistake of fact and not by reason of mistake of law. It should be a mistake of fact. It should act with the reason of mistake of fact and not by reason of mistake of law. In good faith, believes himself to be bound by law to do so. So illustrations, I have already discussed this one. A soldier fires on a map mob by the order of his superior officer in conformity with the commands of the law. So he has been commanded to fire on the mob by his superior officer. So A has committed no offense. So that is the general exception. A, an officer of a court of justice, being ordered by the court to arrest Y. So he is ordered by the court to arrest Y. And after due inquiry, believing Z to be Y, this is a mistake of fact. He believes Z is Y. So then arrest Z. Actually, it is a mistake of fact. So A has committed no offense. So you can take that general exception. Mistake is a slip made not by design but by mischance. Under English common law also, an honest and reasonable belief in the existence of circumstances which would have made that act or an innocent act has always been a valid defense. That is in torts, a law of torts or common law also, that is a defense. An honest and reasonable mistake stands, in fact, on the same footing as the absence of the reasoning faculty in infancy or lunacy. That is Tolson's case. You have explained at some point of time in our coaching also. Ignorance of fact is excusable. Ignorantia of fact.
The full form
Mere
is
forgetfulness
the full
facti.
form is ignorance a facti excusat.
Yes, yes.
Go ahead.
Ignorantia factus excusat.
Yeah. Here
Mere
excusat.
forgetful is not mistake.
Yeah.
Mistake of fact implies mistake as to true identities or mistake in sensory perceptions, such as temporary distortion of imagination. That is, distortion of imagination is confused with the imagination. For example, he has arrested Z, mistaking him to Y. So that is because of his imagination. So mistake of fact is no defense also at sometimes. Mistake of fact is no defense if the fact itself is illegal. One cannot do an illegal act selling adulterated foodstuffs and then plead ignorance of a fact. No, I don't know it is adulterated foodstuff. That's why I have sold it. It cannot be taken as exception because it is the act itself is illegal. Thus, a person cannot, by mistake of fact, shoot X and then plead in defense that he did not intend to kill X at all. No, I did not want to X. I did not want to kill X. He cannot say like that. But mistaken him for Y when he wanted to kill. So then he can take that plea also. Similarly, taking an unmarried girl under the age of 18 years out of possession and against the will of her father was held not to be a good defense to an indictment for abduction because the accused intended to do and did a wrongful or immoral act. Because that girl has not crossed the minority and without the father's consent, will of the father, he has kidnapped her and took her as a hostage and wrongful confinement. So the act itself is immoral and illegal act. So this was decided in R versus Prince, R versus Princess. However, where A sees a young girl about to jump into the river, believing that the girl is about to commit suicide, A grapples with her and drags her away. He is not guilty of molestation. So in this case, this is not an illegal act. If A sees a young girl getting drowned in water, then he grapples her and saves her. Then afterwards, he cannot be held guilty for molestation because he has grabbed. That cannot be considered as molestation.
But actually, the God was actually worshipping the sun.
Yes, although it may turn out that the girl was actually doing sun worship. The maximum respondent superior act done by the order of a superior has no application in criminal law. So act done by the order of a superior, that is held legal because he has operated under the orders of a superior. So in criminal law, there is a general exception for it. The order of a superior to an inferior servant to commit an offense is not a valid defense. Thus, where under order of their Nayak, 3 sepoys of a regiment fired a shot at a mob which otherwise was by no means violent. It was held that they were guilty of culpable homicide. Okay, if that procession was non-violent, then they cannot say that order is given by the Nayak and we have fired. They will be held liable for culpable homicide. It was held that they were guilty of culpable homicide not amounting to murder and they were not bound to obey an illegal order. So they should not obey an illegal order also. They can obey a legal order, but they cannot obey an illegal order. They can fire on violent mob, but they cannot fire on non-violent mob. If commands are obviously illegal, an inferior would be justified in refusing to execute such command also. They can say, no, we don't want to fire on these innocent protesters because they are non-violent. This was held in Gurdat Singh case. One cannot plead ignorance of fact.
जय हिंद.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता. पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा. विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा. तव शुभ नामे जागे तव शुभ आशीष मागे. गाहे तव जय गाथा. जनगण मंगलदायक जय हे भारत भाग्य विधाता. जय हे जय हे जय हे जय 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 हे. अहरह तव आह्वान प्रचारित सुनि तव उदार वाणी.